Magandang araw po sa inyong lahat at welcome po sa isa na namang video mula sa Payo ng Abogado. Ang module po natin ngayon ay reviewer para sa criminal procedure. Ang ibabahagi namin sa inyo ay ilang mga katanungan. Ang iba ay may sagot at ang iba naman ay wala. Para sa mga multiple choice, ang mga sagot ay matatagpuan sa susunod na video. Ready na? Let's go! Question: what system of criminal procedure is the detection and prosecution of offenders? What system of criminal procedure is the detection and prosecution of offenders are not left to the initiative of private parties, but to the officials and agents of the law? A. Inquisitorial. B. Accusatorial. C. Adversarial. D. Immaterial. Question: may procedural rules be suspended? Answer: procedural rules can be suspended if matters of life, liberty, honor, and property are at stake. Question: on what time does the jurisdiction of a court in criminal case is determined? Answer: the jurisdiction of a court to try a criminal case is to be determined at the time of the institution of the action, not at the time of the commission of the offense. Question: the jurisdiction of the first-level courts over criminal cases shall include all offenses punishable with imprisonment not exceeding A. 4 years, B. 6 years, C. 10 years, D. 12 years. Question: METC stands for A. Metro Trial Center, B. Metro Trial Court, C. Metropolitan Technique Court, D. Metropolitan Trial Court. Question: as a rule, what court shall exercise exclusive original jurisdiction in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body? A. Supreme Court, B. Court of Appeals, C. Regional Trial Court, D. Metropolitan Trial Court, Municipal Circuit Trial Court. Question: blank shall exercise appellate jurisdiction over all cases decided by metropolitan trial courts, municipal trial courts, and municipal circuit trial courts in their respective territorial jurisdictions. A. Supreme Court, B. Court of Appeals, C. Regional Trial Court, D. Metropolitan Trial Court, Municipal Circuit Trial Court. Question: give the reason or reasons why the criminal case should be filed within the territorial jurisdiction of the court. Answer: number 1, necessity and justice. Laying the venue in the locus criminis, place where a crime happened, is grounded on the necessity and justice. This is for the benefit of the accused so that the accused can have easy access for his witnesses and to be used by him for his defense. 2. Territorial jurisdiction. Trial court can only hear and try cases involving crimes committed within its territorial jurisdiction. Rule on summary procedure prevails as against the rule on criminal procedure. The court feels that if there be a conflict between the rule on summary procedure and Section 1 of Rule 110 of the Rules on Criminal Procedure, the former should prevail as the special law. Question: may the prosecutor's office single out a particular respondent suspect? Answer: yes, the prosecutor's office has the discretion who to prosecute. As to petitioner's contention that his co-accused should also be charged, it should be noted that the discretion who to prosecute depends on the prosecution's sound assessment whether the evidence before it can justify a reasonable belief that a person has committed an offense. Examples of cases that is commenced by complaint and subscribed by the offended party. Keyword: casada, concubinage, adultery, seduction, abduction, defamation, acts of lasciviousness. Question: when is an information defective? Answer: an information may be defective because the facts charged do not constitute an offense. The dismissal of the case will not necessarily follow. The rules specifically require that the prosecution should be given a chance to correct the defect. The court can order the dismissal only upon the prosecution's failure to do so. Question: what is the ruling of the Supreme Court if the exact date is not specified in the information? Answer: in rape cases, failure to specify the exact dates or times when the rape occurred does not ipso facto, by the mere fact, make the information defective on its face. It is sufficient that the complaint or information states that the crime has been committed at any time as near as possible to the date of its actual commission. Question: what are the options of the judges of the regional trial court if the information is filed in the said court? Answer: 1. Dismiss the case if the evidence on record clearly failed to establish probable cause. 2. If he or she finds probable cause, issue a warrant of arrest. And 3. In case of doubt as to the existence of probable cause, order the prosecutor to present additional evidence within 5 days from notice, the issue to be resolved by the court within 30 days from the filing of the information. Qualifying circumstance must be alleged in the information. To be appreciated as a special qualifying circumstance, minority and the special relationship must both be pleaded and proven. In the absence of one or the other, or in the absence of the appropriate allegation in the information and proof, no special qualifying circumstance exists under Article 335. Question: how criminal actions commence? Answer: all criminal actions shall be commenced either by complaint or by information. Question: how criminal action is prosecuted? Answer: all criminal actions shall be prosecuted under the direction and control of the public prosecutor. Question: how about if there is no prosecutor? Who will prosecute? Answer: the offended party, any peace officer, or public officer charged with the enforcement of the law violated may prosecute the case when the prosecutor assigned to municipal trial courts or municipal circuit trial courts is not available. This authority seizes upon actual intervention of the prosecutor or upon elevation of the case to the regional trial court. Salamat sa inyong panonood. Antabayanan ang sagot sa susunod na video. Salamat!